I'm Daria Farrow from Pediatric Hospital Medicine, Clinical Informatics, and wearing my hat today as a representative of the innovation ecosystem. Welcome. If you haven't already in the chat, just drop a little information, your name, role, research, and clinical operational affiliations. My clicker's not working. A little bit about the innovation ecosystem. We are a group of people trying to help facilitate innovation by preparing CHOP faculty and staff via opportunities to strengthen community, build connections, and increase capacity related to innovation and entrepreneurship. This series, the Learn and Connect series, is our event series aims to create training, skill building and networking, research sharing for everyone at CHOP and in conjunction with the Penn neighbors that we are very closely physically aligned with and in lots of other ways. Our content draws a lot from the Academic Entrepreneurship Medical Scientists ebook to provide just-in-time learning. So if you haven't had the opportunity to explore that, we encourage you to do so, and we can make these slides available to those of you joining us online later, so you can connect with that. And then we were just talking about it here in the room before we unmuted you, but we also host a course. We piloted last fall. We have one of our first cohort 1 participants in the room. He was just reflecting on his experience. It's a short course on the fundamentals of academic entrepreneurship, designed as a professional development course. Takes place in the fall over 7 Wednesday afternoons. Really fun. And our applications are now open. It'll be on a rolling basis. So you can find out more about that by using the QR code, or we will send the link out or put it in the chat as well for more information. And as always, you can email us as well to find out anything more that you're hearing. Without further ado, I want to turn it over to today's speaker. Hi, Professor Cynthia Dahl from Penn Law. She runs the Detkin Law Clinic, in intellectual property. She's going to tell us a little bit more about that, but it's essentially a teaching law firm. And so in addition to her experience in actually practicing in the intellectual property space, also has a lot of experience teaching this to lots of different groups of learners. So without further ado, I'm going to turn it over to Cynthia to guide us through this.
Thank you so much. Hi, everyone. Thank you so much. This is just like my students. Everyone is in the back of the room. There is actually a handout that I think is going to be made available. It's hard copy in the room, and I think it's going to be made available in the chat for those of you that are joining us over Zoom today. Thank you so much for having me here. This is always such a pleasure to come and speak to early stage entrepreneurs and people that are creative and thinking about the next amazing inventions and next great steps. So I'm here to tell you briefly about the program that I run at the law school, because we may be of interest or help to you. And then we're going to go through some basics of intellectual property, and then we're going to end with, and we're going to do a quiz sort of in there, and then we're going to end with a couple of lessons and things that we could talk about in terms of specifically healthcare innovators and working with your tech transfer office. Okay. So this is a quick picture of where I spend a lot of my time. This is the basement of the Silverman Hall, which is just 4 blocks away from the medical campus, where we have our teaching law firm. And I run what's called a legal clinic, which means I have 8 law students who are about to become lawyers and have never had clients and do work for free, basically so that they can learn. We have an application cycle that I'll tell you more about in a second, but you should know that all of these law students, although they're not licensed, are closely supervised by practicing attorneys. And we are one of 9 clinics. And so if it's of interest to you, there's also an entrepreneurship legal clinic and other sorts of legal clinics in the same facility. So our specialization basically is to help early stage entrepreneurs in particular think through their IP strategy and to implement it. And so what does that mean? It means looking at the invention and trying to figure out protectability, and then doing the contracting or the applications that would ensure that the entrepreneur owns what they have created. But we also work a lot with Penn's Tech Transfer Office and with CHOP's Tech Transfer Office. And the way that we do projects for both of those institutions is basically for the institutions, we help to do some patent searching to think about protectability, and we help to think about how to commercialize this product. And so we do something called a freedom to operate opinion, which I'll talk a little bit more about later. But in a nutshell, we serve student and faculty and Penn and CHOP innovators. See that 5 times fast. This is my contact information if you'd like to know more about the program, or if you have questions after this presentation, I'm happy to. We have an application cycle in August and in December. You can find out more about our product, our project, our program at that website, but we look at applications twice a year to take student projects. Okay. So as I mentioned, I'm first going to just situate us to speak a little more broadly about intellectual property. And then we will go rapid fire through the types of IP because you're getting a quick introduction today. If you have any questions, though, please do follow up with me. And then I wanted to spend some time going through some common IP misunderstandings or mistakes, some issues that will come up as you are innovating within CHOP. And we can talk a little bit more about what that means. Okay, so putting it out to the folks in the audience, if I said intellectual property, what comes to mind?
Invention.
Great.
Assets.
Assets. Ooh, I like that. Anybody else?
What about people online?
What'd you say? People online. People online. Put into the chat. What comes up when you think about IP?
Okay with that.
Publication.
Fabulous.
Or research finding, protection,
Okay.
novel ideas.
Great. And so we have people coming at this from different angles, and I love that. Some people are giving me examples of things that can be protected. Some people are giving me ways that we protect, and some people are giving me things that like reasons why we might protect. And that's actually where I would like to land, because this is what I always introduce my students to when I'm talking to them. I want you to think about IP as a means to an end. Actually, IP is a business tool. Now, in a university setting, we do a little more protecting than we might do as an early stage entrepreneur, because everything is very early. We're not sure what's going to happen to you yet. And frankly, there's more money than an early stage entrepreneur has. But I want you to think about it really boiled down in this way, that purely we should be protecting IP in order to do something with it. It is a business tool. It's a means to an end. And this means that even if you work very hard, it may not be able to be protected by strict IP tools. It doesn't reward effort, it rewards advances, because it's a deal that we've got between the government and society, that basically we want everyone to be able to build on everyone else's invention. So we want things to be open, but we want to incentivize you to create. So we're going to give you some limited rights in order to basically incentivize you. And you and I can talk about whether that philosophy is right or wrong, or whether we agree with it or not, but I'll just tell you, that's the rubric that we're working under. So it covers advances, not effort. And that has interesting implications for when and how you protect. Okay. It also translates, some people on the chat said invention and other sorts of things like that. It translates that invention into value. So it gives you a tool, and you can use that IP basically as a bargaining chip. You can use it as a negotiating strategy. You could use it, to indicate value if you're trying to get money for your early stage invention. So it translates invention into value, and it makes it into a tool. Again, back to the philosophy, of course, we've got things like Creative Commons and open source. That's not such a concern in this school. I talk about that a lot when I'm across the street at the engineering school. But a lot of medical devices, a lot of drugs, a lot of medical inventions, patent is incredibly important because you've got a lot of R&D dollars that need to be invested. And something we'll talk about briefly, but is an important thing to think about. You get some rights in the United States just because you use certain things. You get certain kinds of rights. You get more rights if you actually apply to the government to get some registrations, but you get some rights, for example, in copyright and trademark, just because you're using. And so there are a lot of options available to an early stage entrepreneur as you're building your company. But I want you to think about my whole discussion today is about IP as business tool. Okay, so with that, I'd actually like you to take out your quiz, and we're going to spend no more than like 3 minutes, quick, filling this out. So on the left side of the quiz, you've got creations, and on the right side, I'm asking you to think about the tools that we might use to protect them. The available tools are at the top. Just take a couple minutes to jot in, and remember that you can say none. There are some tricks in here. Okay. Enough of the people in the room. You look like you're finished? Ready to talk about it? Okay. And let me tell those of you in the room and those of you online, if you have any questions as I go through this for the next 30 minutes or so, please put your questions in the chat, folks online, and please just raise your hand in the room. I'd really like this to be relevant to you, and our time will go quickly. So let's make sure that we get, yeah.
I'll start with just first questions up there. You said earlier, like, some patents we already have access to in terms of use, like copyright. Can you expand on that a bit more?
So what I meant to say was that you have rights even before you register. That does not count in patent world, but it does count in copyrights and in trademarks. And what I mean by that is we have parallel rights called common law rights that are given to you just because you are using. And they give you limited rights to tell other people, to exclude other people from practicing. So for example, if I've been using my mark, Pine Street Pastries, for 10 years, and I've never actually registered that trademark, but I've been using it, I have the right to put a TM after it, and I have the right to tell someone else that moves in next door and opens up Pine Street, I don't know, Porcupines, that they need to stop using it because I came first. Terrible example, but you understand. All right, it does not work in patent world, though. Patents are different.
Thank you.
Does that answer your question?
Yes.
Great. Great. Please, more questions. Please let me make this relevant for you. Okay, so turning to the first question on the quiz, the robotic hand sends impulses back to a computer via sensing pads on fingers. So what kind of tool would we probably use to protect that? Anybody?
Patent.
Patent. Great. Anything else? All right, let's talk patent first, and then we'll circle back to the anything else's. Okay. So, patentable subject matter. These are very, very powerful tools, folks. You don't get patents over everything, and so there's only a limited number, a limited universe of things that are eligible for this very powerful tool. The first thing that we look at is patentable subject matter. Patents can cover machines, that's sort of classic, the cotton gin, right? But they can also cover processes, formulas sometimes, plants sometimes when they are not naturally occurring, when they're made in a lab, and sometimes software. And the way that we cover software through patent is basically we jerry-rig it under machine. We say, this is a code that turns this computer into a machine that operates like no machine has ever operated before. That's basically what we're doing when we're patenting. So it goes back to machines because, of course, when the patent law was put on the books, there were no computers. So that's the way that we get it in.
Could that mean, let's say the cotton gin already exists, but then how about if you make a significant advance on how the cotton gin works, would that be a new patent or would that just be the same patent? Or?
Terrific question. You get a patent over the improvement only. And a really important point here, if you are the improver, but somebody has an active patent over the cotton gin, let's say you make a cotton gin that has a bell, and the bell makes the cotton gin somehow much more commercially viable. You can't build your invention until you get a license. So you have a patent, and you still can't do anything with it because it's dependent on practicing somebody else's invention. So that's a great point about offensive and defensive strategies here. You can get a patent, but if you want to commercialize, you also have to think about the licenses that you need. Okay, so patentable subject matter, machines like cotton gins, improvements on machines like cotton gins, and a couple of other things. It also has to be new. Not just new in the United States, new around the world. Patents are territorial, but you can't get a US patent over something that someone has already thought of in Japan. If they have disclosed it, if it's obvious that they've thought of it, you can't get it here in the United States. If you want to get a patent in Japan, you can get it if it's new in Japan, but you can't get a patent. The point is, you can't get a patent anywhere if it's not new everywhere. It has to be also non-obvious, and this is not judgy. This is actually a legal term that means a person having ordinary skill in the art. So a person who is operating in that space would not have thought to put 2 prior existing or 3 prior existing inventions together to get yours. So basically the point is it has to be new and it has to be so great that we're going to give you a lot of this very powerful tool over it, but it has to be new and like move the art, advances to the art. Okay. Yeah.
Yep. I'm just asking on behalf of other people if this is not useful to you guys. The software one is challenging because it changes over time. You know, like you keep upgrading your software. So, you know, the algorithm, like, you know, software never is stable. So as opposed to a machine that can be maybe stable over time. And so people keep improving on their software.
The improvements, though, if it doesn't change the functionality to a point where it is new or non-obvious, it has to be like not just a version upgrade, but like a whole new machine. Then you can patent potentially that new thing. But you're talking about the range, the realm of copyright, which we'll talk more about in a second, where you're getting derivative works. And so little derivative changes can get additional IP coverage, probably not in the patent realm. But you're right, patenting software is a mess. Patenting software is hard.
Just to clarify, you know, so in terms of patents, when you apply for a patent, is it a bit deterministic? So if I apply my application to you, to your law firm, to another law firm, to another law firm, it will get the same answer? Or is it subjective to how the application is sort of presented?
You're saying if you're an inventor and you go to my law firm or another law firm, will you get the same patent?
Or approval, yeah.
The same approval? Okay, so patents, just making sure I understand. Patents get approved by the US Patent and Trademark Office. You have a lawyer try to draft it in a way that you're going to get the most coverage and that you're going to get it through. Would you get exactly the same patent if you went from firm to firm? No, because it's like asking 2 different people to draft a novel about X, right? But X is the inventive concept. And let's hope that between you and your lawyers, every time you're talking about it, you and your lawyers identify the same inventive concept. So while the words may be slightly different, you're still covering the same invention. Does that help?
So the X part is deterministic and the rest is sort of the boundaries of where you can get your patent coverage.
The X is the theme, the inventive concept, and the patent should be drafted fairly closely person to person, but of course we're people and we all draft slightly differently, but lawyers that draft patents are trained in that language, and so it's as if you're getting, you know, you're getting a similar novel out of different people. Okay. Importantly, in our country, the first person to file gets the patent, and that is a change in the law of the last decade. Happened at the beginning of the 2010s. Rest of the world is similar, so we brought ourselves in compliance with the rest of the world. But what does this mean? This means that if you have invented, you probably should patent quickly. The question is whether you have the money to do it as an early stage entrepreneur. It's a little bit different if you're working at the university. But if you're an early stage entrepreneur, you have to have found the support, get the money, and your inventive concept needs to be far enough along that you can describe it because it has to be fully enabled. So if you're still in the process of coming up with something, the art is figuring out when do you have enough to file a patent. And that's something that you can talk to a lawyer about. But as soon as you have something, you probably should file something. And one thing that you can do, and we can talk about this if this is of interest, is you can file what's called a provisional patent, which sort of gets a date on file while you are still developing. And then even if you continue to develop, at least the stuff you had as of the filing date, you get that early date for. And that might be very important if you're in an industry where everybody's inventing and it's moving really quickly. You might want to get that provisional patent on file so that you at least preserve the rights to what you already know. And when you're looking at patents, you always want to get to the very end of the patent to see how much it covers. These are the claims. They're numbered paragraphs, and they talk exactly about what the invention is and just how broadly you're claiming rights over the invention. And you can have, they're very hard to read. If you've never read a patent before, they're very hard to read. And it's because the language seems circular. And part of why it seems circular is because we're trying to get at different kinds of infringers. So you want to describe not only the thing, but the way the thing operates, its method, and the way the thing fits in with other things, the system. And so that way you can go after someone who's a device creator or someone who has a different device that does what yours does in the same way, but with a different kind of a device, or somebody that manufactures a whole system and your invention's only part of it. So that's why we draft the claims in language that seems kind of circular. Okay. Any questions on patents? I know that that's probably where most of your interest lies, and so I'm happy to spend more time on patents.
I have a question. So I imagine it does cost a lot, and you say like an academic center, if you're inventing within academia, that you have more funds available to you because you're within a larger universe of within like CHOP or Penn or something like that. Is it, how do people convince their institution to spend their money on getting you a patent?
Great point. So first of all, they are the owners,
Okay.
which is one thing that we're going to talk about later. But if you are an academic entrepreneur and you're working for an academic institution, they own your technology. They own your patent.
Right.
They own the technology. They decide if a patent should be filed on it or not. So how do you get them to decide to file a patent? Well, I think that you, first of all, can talk about how far along you are, what you know. You're going to know more about the prior art, about the newness of your invention than anyone else. And so you can describe to them why it is new, why it is non-obvious, why it not only likely will get a patent, but should get a patent. And if you know anything about the commercial viability of it, can this patent be licensed to someone else? Who's going to want it? Is it seminal? Is it just incremental, or is it seminal? It's going to move the art in a whole different direction. That's the sort of thing that weighs in favor of patenting. There was another question too, or did you have the same question?
No, mine was actually around, you talked a little bit about non-obvious, and I could see that being, especially in like a field where people are trying to think of the best way to take care of a patient and like put things together. How do you identify how do you determine whether or not your patent is non-obvious, or your potential patent, I guess, is non-obvious?
You will have a sense, being the inventor, about just how far this moves the art. The examiner will do what's called a prior art search, and they will look not only at your other inventions, but at everyone else that has filed a patent in this realm, and they will make a decision about whether or not this is basically just putting together a couple of other things that already existed, or if this is, oh, wow, this is different kind of an invention.
I think that we have Cassie Tran from our Office of Technology Transfer on the line. And, I don't know if this is like an appropriate analogy, but I sometimes think of this as like a TSA analogy. It's like, see something, say something, where it's like, if you have I think as the person in academia, like working on the problems, like thinking of the solutions, like it is an advantage of being in the academic environment that we have resources like the Office of Technology Transfer, where we can say, you know what, there's actually an online tool where you just go and you say, here's my idea, and you like put the idea in, and someone from the office responds to you pretty quickly to say like, oh, can you tell me more? Like, what's this about? And like, I think that for me has always felt like I've done this exercise multiple times that I am still not confident that I have any correct answers on this page. And always makes me feel a little bit more like, oh, that's right. This is like a huge advantage of being in an academic environment like this, where we have our Office of Technology Transfer with experts in this, like we're hearing from Cynthia, but also like experts in the office of doing this in the pediatric space who can really help walk through that process. Because I think like, yeah, what is actually not obvious? Like, is this new enough? Like, these are the types of questions that I have found that the office can be like helpful, at least in like, tell me more about this, right? Or whatever elements.
Great points. Remember that this is going to be their technology though in most cases. And so you can ask them about their analysis about whether you've got something new or non-obvious, but it's still their decision about whether or not they're going to file a patent or not. Now, if you invent outside of the university and you get a waiver, then it is yours to to develop, and you can. I'm sure there are so many resources across campus that can help you to decide whether filing a patent over that sort of stuff is good for you.
So what if the institution rejects and says, no, we don't want to file a patent on this? Do you have the right to go then file your own patent?
You need a waiver, but yes. And I think that your Office of Technology Transfer can help you definitely with that. But if they make a judgment, then likely they will say, have that. Yeah, but you need the waiver though, because the presumption is that it's theirs, because we all work for them. Okay. So let's quickly blast through a couple more of these, just to give you sort of a context. Manuscript for an academic book. Someone said article, I think, or publication online. What do you think what tool could we use to cover that? Copyright. Yeah, okay. So I mentioned this because I was talking about code and about derivative works, but really quickly, copyright covers what you would traditionally think about as original expression that is fixed in a tangible medium. So examples would be books or films or manuscripts or software, because it's written, it's in code. Okay. Really long term, longer than patents, but it has a couple of problems with it. First of all, the last one on the bottom is it only covers expression, not idea. So if you are a coder, you understand that there are lots of different ways to code the same result. So you can't claim copyright infringement if somebody codes in a way that doesn't copy your actual code. So it's kind of what we call thin coverage. This is one of those cases where you have some automatic rights just because you create. If that's of interest to people, I'm happy to answer questions about that, but you do not need to file to get some coverage. You need to file to be able to sue in federal court. You need to file to get some automatic, what we call statutory damages. You've seen the scary notice in the beginning of all the movies that you watch that write statutory damages. You need to file for that. If you do file, then you can sue and get the statutory damages can really add up. But copyright is helpful for things like your websites, photos that you use on your websites, of course, any of your publications, and to some extent, software. Questions?
If ChatGPT writes it.
Excuse me?
If ChatGPT writes it.
If
you
tell
tell ChatGPT to
writes
write
it?
something.
Right now, it is not copyrightable.
That's what I thought.
Also, if you tell ChatGPT to come up with an invention for you, not patentable. People have tried. It is right now being fought. There are a couple of cases that have been denied, but it's right now in our courts, actually. Okay, product name or logo, anybody?
Trademark.
Trademark, okay. This will only come up, okay, if you launch your own company and if the company that you launch has a good or a service that you are selling to the public. Otherwise, it's not going to come up. But trademarks are sometimes the most powerful tool for an early stage entrepreneur. If you can't afford a patent or a patent doesn't work for what you've invented, and you just want to get out first and fast with something, sometimes it's all about your name and your branding. So it can cover any source identifier, which can be name, logo, tagline, smell, song, whatever ties the good or service in the minds of the consuming public to you. It's perpetual, so long as you continue to use that brand to sell your goods or services. This is one of those other things, kinds of IP tools that you do not have to file for, but you have rights already. You get more rights if you file. Back to my terrible, I don't know, Pine Street, whatever I said. Pastries, yes, exactly. And the standard is that you cannot get trademark rights over something that someone else is already using for similar goods and services. So you can think about how Apple might be used for computers, but also for a daycare center, and nobody's going to confuse that. Nobody thinks the daycare center is owned by Steve Jobs, right? But if somebody decided to sell phones or antennas or other sorts of things under Apple Computer Company would probably come calling, and they wouldn't be able to get those federal rights. So there is a registry where you can search to see if someone else is already using your name or a similar name for similar goods and services, and then you know to pick another name. Okay, data. All data. Data on normal range of visual acuity across child populations. Is there a tool that we could use to protect data? It's hard, but trade secret is the one we got. Trade secret and contracts, actually. So trade secret covers a lot of things that patents might be able to cover. And so they operate together, but they're not completely overlapping. So trade secrets can cover things like formulas, business plans, pricing, vendor lists, supplier lists, things like that. And the point is that it has to be something that is commercially valuable to your competitor and that you take reasonable measures to keep secret. And if you do both of those things, then you can accuse someone else of misappropriation if they steal it from you. You can think the classic trade secret case was the Uber case, where one of the employees left and downloaded something like 14,000 documents off of his computer and just walked out the door with them, took them out. That is classic trade secret. It's often not that cut and dry, but basically commercially valuable information that you've taken reasonable measures to keep secret. You don't have to file for this coverage because, of course, if you tell the government about what it is, then you are revealing your trade secret, okay? So it's just internal processes, and what is reasonable depends on what the thing is. If it's something that can physically be locked in a safe, lock it in a safe. If it's data, then put it behind passwords on lockdown computers, control access. If it's something in a lab, for example, control access to people that wander through, have sign in, sign out sheets, things like that. Okay. How about our gene? Isolated and identified. Protectable?
No?
Not, and why?
Body.
The universe
Found
created that gene.
Out in the world, found in the body. Now, you might have been a genius to actually figure out what gene that was. And it might have taken years to isolate it and identify it. Sorry, not patentable because it exists in nature. It's not patentable subject matter. We had a big Supreme Court case about a breast cancer gene a couple of years ago. You probably saw it. And they won half of it because they basically had isolated and chopped the gene. They identified and they chopped it, but that was not patentable, but they manipulated it in the lab and that was patentable. So it's something that they invented. Okay, speaking of, a molecule that's manipulated in the lab, protectable? Yes. Okay, algorithm that runs a business process. What do you think?
Business process. Trade secret?
Could be patentable because it's a process. Could be protected by trade secret if you keep it secret and it is is commercially valuable and take reasonable measures to keep it secret. Algorithms can sometimes, if they're pure and it's pure math, not patentable. If it actually rises to the level of a technological solution to a technical problem, we can start talking patents. But algorithms are tough. Okay, brilliant. You all get an A. That's wonderful. Okay. So let's talk. Let's see, we have. Oh, good. We have a little bit of time. Okay. I'm going to get into some of these issues that I was thinking about when I was putting this together and thinking, like, what what sorts of questions do I think particularly an academic entrepreneur would have? And so we'll use all of the stuff that we've just been talking about sort of as a context to talk about what kinds of inventing goes on in an academic institution. And we have Cass on the line, right?
Yes.
Okay. And
I think so. Cassie, if you could put in the chat that you're.
Yes, I'm here. I'm on the line. I also see my colleague Audie is here too.
I was just
I
gonna
am
say,
on the
so
line,
Audie
yep.
on the line too, both of our colleagues from the Office of Technology Transfer.
Fabulous.
So.
Okay, so the true experts are here, and so please feel free to jump in. Just start to talk, jump in, add to anything that I'm saying, or correct me if you do things differently or want a message that you do things differently. Okay. But these are some things that I was thinking about talking about. So the first thing, you're working in an academic lab and you're coming up with a ton of stuff all the time. I would recommend that you at all points have just this little chatter going in the back of your head about protection. So as you are inventing things, think about some of the concepts that we've just been talking about. Is it patentable subject matter? Have we actually gone beyond something that is obvious? Is this really cool? Is this a eureka moment? Maybe if it's new, maybe if we don't know, but we really are excited about it, call in the tech transfer office because you might have something protectable here. And that is important. In the university, sometimes we get busy, distracted, and there are a lot of reasons why we invent. We're solving problems, this is our field, we're excited, we're working with a team, not always thinking about like filing a patent. That might be sort of just, maybe your last thought. But do consider it because this is, first of all, it's the university's IP that we're developing. Second of all, if you file a patent, eventually this may become a cool revenue stream for you, whether or not you sign up, to actually run a company or the university licenses it out to somebody, the money will come back to your lab, to your school, and that good work will get out into the world and will help people make the world a better place. And part of why we patent basically is to make sure that, you have the right to exclude other people from exploiting it for a certain period of time. And then the money comes back to you and the invention gets practiced. Okay, so things that we want to think about. Is this patentable subject matter? Is it new and non-obvious? If it's not patentable, should we think about, is it copyrightable? Are there other ways that we could maybe, use copyright to protect it? Or if it's not going to rise to the level of patents, potentially maybe if it's data. Is this data that somebody else would find commercially valuable? Is this data that we should probably think about keeping secret? Then, you could think about trade secrets. So basically, everyone focuses, especially in the university, on patents, but think about it more holistically. IP is a protection strategy. It is a business tool. So think about everything that you're doing and all the ways that you might be able to protect it. And the Office of Tech Transfer can help a little bit with that, as can the clinic to some extent. Okay, so one, consider protection as you are inventing. This one is probably the biggest one because sometimes talked about these really valuable rights, but you can keep yourself from being able to gain rights or exploit rights if you're not careful. And so what I'm talking about mostly here is disclosure, but I'll unpack this a little bit. So first, I would recommend that you set a schedule to kind of audit what you and what everyone in the lab or everyone in your group are doing. So always before publications, but just generally as you're going along, think about what you're inventing and what you've come up with, and then file disclosures with the CHOP Office of Tech Transfer. They will help you to decide whether this is patentable or not, or whether it needs to continue to develop. But I guarantee, and please chime in, I know that they want to know before you publish what you've been up to. Because the worst scenario is when, when you have come up with something patentable, you are ready to disclose it to the world through a paper or by going to a conference, and you think, I forgot to tell Tech Transfer, it's Friday at 5. I'll give them a call before I leave and go to my weekend conference. Because now they have to, some poor lawyer somewhere is going to have to draft a provisional like on Friday night and put it in. And it's probably not going to be as robust as you would have wanted it to be. You're not going to be available to answer questions. So it may not protect all of your rights. So get in front of that and be a little bit more proactive about auditing, particularly when you've got a publication coming up. Why is publication so important? I talked about patents having to be new. And if you disclose, and disclosure can be formal publication, disclosure can be like a publicized talk, disclosure can be a meeting outside of NDA. It can get that granular, but particularly if you're going to present at a conference, definitely disclosure. And if you disclose, it's no longer new, and that keeps you from being able to file patents in many countries around the world. You can still file in the United States, but it starts a clock, and you can only file in the United States for a year after you disclose. Okay, so disclosure is really important, and so before you disclose, think strategically about whether or not you want to save some of those rights. Okay, keeping notebooks, lab notebooks used to be pretty important because we were not first to file, we were first to invent, and you had to be able to prove, like, I knew this before you did, so I should get the patent. That's not the case anymore. But we do have something in our law still where it's important for you to be able to prove that somebody that filed later or somebody that filed earlier than you didn't get it from you. And so keeping lab notebooks is still important. Be sure that whatever disclosure policy you've decided you're going to abide by, your whole team understands it and agrees to abide by it too, because they can disclose. And you don't want that to happen. If you're being really careful, you don't want someone in your team inadvertently to disclose. Time clocks was about that year. So if you do disclose, make sure the Office of Tech Transfer knows that, and so that they can take care of those rights. NDAs, non-disclosure agreements, they help to keep you from being deemed to have disclosed. They help for patents and they help for trade secrets. Remember, reasonable measures to keep secret. NDAs can help with that. NDAs are not always appropriate, however. And so when, for example, you're going in to talk to a potential investor, they will not sign NDAs. And so what do? You keep it high level. And when they get excited about you, then they will sign an agreement that has a confidentiality provision in it. They don't like to sign NDAs because you leave and somebody else comes in, and they leave and somebody else comes in, and they're seeing so many people. And if they have a specialty in a certain area, they're probably going to see someone that has an invention somewhat close to yours at some point, and they don't want to be accused of sharing information with that other person when they didn't. So that's part of why they don't do that. Okay, ownership of IP is tricky. We've talked a lot about the fact that if you invent in an academic institution, that by and large, it's what you invent is owned by the institution. But ownership comes up in a couple of other instances that you should be aware of because they're traps for the unwary. So first thing, funding agreements. Make sure that you look at the terms of funding agreements to see if the funder is going to claim any ownership over what you are being paid to create, because that may get in the way of rights. So read your contracts carefully if you've got funding agreements. Secondly, when you're collaborating with someone from another institution or from someone outside the institution that has an obligation to assign rights to somebody else. So make sure when you're collaborating that you're clear who's bringing what to the table and who owns that thing. And if you create together, who's going to own that thing? The Office of Tech Transfer is their masters at helping you to figure this out, but just know that this is a trap. And consulting agreements. And this is in particular if you launch your own company at some point. If you hire someone to create for you and you pay them, you don't own what they create, even if you pay them. You have to get in writing that they assign to you. And it's not the same to say, I shall own or I will retain rights. It's not, doesn't work. It has to actually be the A word. The consultant assigns. And if the A word is not in there, you don't have rights. So be really, 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 really careful. Okay.
Explain,
This is my little plug for the Office of Tech Transfer. Go
can
ahead.
you explain the difference between ownership and inventorship?
Hmm?
I think
And
that people-
authorship. We'll take them
And
both up.
authorship, yeah, people get
Inventorship
confused
and
about it.
authorship. That's the brain that the invention or the creative venture came out of, the inventor or the author. They are often also the owner, because in the United States, we have a policy that if you create, you own. You can waive that right through contract. And so, for example, I am an employee of the University of Pennsylvania, and when I started, I signed an employment contract whereby I got salary, they got rights, they got ownership to what I create. I am an employee. It can also happen with consultants. What they create, they own, except if I have a consulting agreement that says that they assign to me, now I have changed the law, or at least I have changed the practice of how that law would be interpreted.
But in the other direction, if you pay someone, you don't become an inventor, because the inventor is who's brain.
You cannot be added to a patent just for fun. Now, sometimes you're added to a manuscript just not for fun, but for respect or for your contributions. I understand that sometimes that you get added to the end of the list. That's different. You cannot be an inventor unless your brain came up with something that is in the claims. And it's just statutory. That's, and everyone that was an inventor must be on the patent. But the patent inventor, 90% of the time is also the owner, but sometimes is not if it is assigned. Thank you, Flora. That was a good point. Yep. Okay. Let's wrap it up here. Keep in contact with the Office of Tech Transfer. They're awesome and they're there to help you. Just because you have invented something and they've decided to patent it does not mean that you just wipe your hands, free and that they can use your help. You know more about the invention than anybody else. You probably know more about the prior art, the other art out there, what other people are working on than anyone else. And you probably know more about the commercial prospects for this invention than anyone else. So help them to draft a robust patent application by telling them a little bit about the universe around your invention. Help them to license it by telling them about the universe around your invention. So honestly, don't just let it go. If you want a robust patent that maybe you at some point will want to license back from the university to exploit and start a company, or you just want a really good patent to be able to license to other people and protect your invention, you can guide them. Two last slides, and this is after when you have become an academic entrepreneur outside the university, if you've decided to launch a company, some things to keep in mind. First of all, what technology do you need to license in order to practice? Way back 40 minutes ago, we talked about the cotton gin and the improvement on the cotton gin. If you've got the improvement, clearly you need the patent over the improvement. So if that is left at the university where you used to work, you got to license that. But to commercialize, you might also need to approach Mr. or Ms. Inventor of cotton gin and make sure that you've got freedom to operate, it's called. So freedom to operate means you can commercialize without an infringement suit. So every technology that you will need to practice in order to get your invention out into the world, you need to investigate whether you should license it. Make sure that you contract with your employees, your contractors or consultants, and other founders. We've talked about the dangers of not contracting with consultants or employees because what they create, they own if you don't contract with them. But founders also, and do it when you're friendly. Figure out who's bringing what to the table and what happens if in the very small chance it goes south and you have to separate. Make sure that you understand what's going to happen. How does that interplay with equity, for example, but contract with your founders. Make sure that everyone that is a founder signed an assignment to the company because you want the company to own all of the assets, because you want someone to invest in the company and you want to have one one entity basically controlling all of the IP. And then last slide, non-compete language is a little tough, but for trade secret purposes, you want to make sure that your trade secrets stay with the company. And so you want to think about your employment agreements that have basically that last even after someone leaves your employ. So a tail on your confidentiality obligations, basically. So anything you learn here, you can exploit for 5 years, something like that. You gotta be careful how you draft it, because you don't want to keep someone from making a living, and right, and you want these to be enforceable. But you should be thinking about how to be strategic about protecting your trade secrets. Trademarks, we talked about, any source identifier you should think about trying to protect, and that goes for reserving the domain name as well, and registering the company. By the way, these are 3 different registries. Just because you get a trademark doesn't mean that you've registered to do business as a company, doesn't mean that you've reserved the domain name. So if you really like a name, you probably have to register it 3 times for those 3 different purposes, or else somebody else will get the trademark over what you're calling your company, or somebody else will have the domain name over what you would really like to trademark. So if you really like it, you should investigate all 3. And I talked about this freedom to operate. You can't do anything with your product if you don't have the rights that you need from other people. Okay. Love to you all, and I'm open for questions.
Wonderful. So you can put your questions in the chat, and I think, Cindy alluded to some of our processes with our Office of Technology Transfer. So Cassie, I know that you had kind of pulled up a couple of slides that if you wanted to share a little bit more details as people are putting questions in the chat about any other details about our chat processes to share.
I just want to emphasize, disclosing to OTT before your public disclosure. As Cynthia mentioned, that's publications, conference abstracts, conversations with those outside shop. The why is because you can lose worldwide rights to your invention if you speak about it before you disclose it to us, before we have time to kind of make a provisional patent filing decision. And typically, you're going to have some supporting data, proof of concept data, prototype, but we encourage getting into contact with us early and often. We can always kind of advise when is the actual, right time to protect an invention, but the earlier the better for us. How to disclose, of course, if anyone is unaware, we have this invention disclosure portal. The link, you can see it here. And I think these slides are going to go out to people after the talk, so you can go through them later at your own leisure. But I also wanted to just pull up the slide of kind of working with the tech transfer office and our process once we actually get your invention disclosure. And so you can see it in this kind of infographic above. It comes in through the inventor portal. There's sort of a intake process once it gets into our database where we kind of look at and kind of confirm the inventors, the funding sources. Are there any third-party rights that might be involved? I think Cynthia alluded to this with respect to who's funding the work. Then it's routed to a licensing associate in the office. So I'm one of those licensing associates, Adi as well. We're the ones who are responsible for essentially assessing your invention, assessing the patentability and the commercial potential of it, to make a decision on whether we would invest our resources into protecting it via patent for things that would go down that path. And I like these 2 arrows here to the informed and engaged investigator, because it is a process in which it's kind of we'll provide you some feedback from our prior art search and our, market assessment, and then you can kind of react to it, and we'll go back and forth. And that's a great opportunity for you guys to be able to provide, information that we wouldn't know about. As Cynthia mentioned, you are the experts in your own subject matter and domain. So it's really helpful, and we work very closely with inventors during this time. Then we kind of come to a patent filing decision if we have enough time, of course. There are those instances that are Not ideal where it's like a last minute thing someone's going to disclose. But when we have the time, we like to kind of put it to the group and kind of present our case and make a yes, no decision as a team. We engage outside counsel to file these applications. And, we help manage the prosecution of them through the different patent offices. And then the last following steps is, with that CHOP IP patent portfolio, each one of us licensing associates are responsible for, we market them. And hopefully the ideal scenario, we find a good licensing partner and essentially determine, how they want to work with us, what type of agreement is required for the commercialization entity. And we're also the ones that negotiate those terms, which include financial considerations. Of course, this is a process that can take months. And lastly, I wanted to include kind of what's in it for you slide that some people are, if you're unfamiliar, it could get you familiar with the revenues that come back from one of those licensing agreements. This is what the breakdown of what happens with it. So 45% goes to research administration, 30% goes to the inventors, 12.5 to the lab, and 12.5 to the department. So just kind of funds the virtuous cycle of research, as we like to say. So that's the spiel from the Tech Transfer Office. Come to us early and often. We handle all things related to CHOP intellectual property. We're here if you need us, and disclose before you go talk about it to the outside world. So yeah.
Thanks so much, Cassie, and thanks for everyone for joining us online. Thanks for Cindy for joining us. If you have the opportunity in the chat to fill out the feedback form, that's great. If you are interested in sticking around and have some questions, I think Cindy said she was willing to hang out for a bit and answer a few more questions. So just want to thank you all for this, and thank you to Cassie and Addie for joining us virtually as well.
Thanks, Sarah.
If anyone stays on, can you speak to one thing that I know challenges everyone as academics is you want to talk about your work in an academic setting. That's what's lovely. So within CHOP, you can, but when you leave and you go on a conference, you also want to talk because you want to get promoted. So how do people navigate that? What is your advice for new researchers for how they do that?
I'm going to ping that to Cassie because I'm sure she answers that question every day.
You got it. So in that scenario that you described, Flora, you're going off to a conference. I'm assuming you had to, write an app, be able to get to the conference. You're presenting a poster or you're giving a talk before you go out to that conference. You'd want to submit a disclosure through that portal that I showed, so you could connect with OTT, and we would be able to file provisional patent before you're going to that conference. So then you would be able to freely talk about, your work without fear of losing rights. So that would be the best course of action there.
Like, let's say if I have an idea about making wireless charging pacemaker, but I don't have IP for the battery, but I have to use those kind of wireless charging battery for that pacemaker. In this case, how can I still submit a patent, or how does it work though? Because I don't have that technology. I just have the idea, but I have to base on that technology for this innovation.
So good question, and I'm going to answer a couple of questions there. So if you want to build a pacemaker and you want to use somebody's physical battery and that battery has patents in it, you can do that because you're going to buy the battery and you're going to put it in the pacemaker, and that's fine. You're not importing the invention. You're buying the thing off the shelf. So that's how we can buy consumer goods and use them all the time and not infringe. Same thing. Now, if you wanted to replace that battery and you wanted to build it, you took it apart and you thought, I can build a better battery. You took it apart, you figured out how to do it. That's also within your right because you can reverse engineer and then figure out how to do it in a different way. But if you reverse engineer it, you figure out how they do it, you read the patent, you understand how they do it, and then you do the same thing and build your own battery and try to sell it, that's infringement. But what you're talking about, I think, is like using somebody else's off-the-shelf product and then inventing around it. That's fine.
And how about like, I see many labs that like the founder is like from the company outside from like pharmaceutical company, like how the ownership go between like does Shop or Penn still have some ownership on that because Shop and Penn are not like the main founder on that particular project.
So pharmaceutical company licensed the patent from Penn and builds the drug, for example, something like that. So I think I'll let Cassie talk to that one, but the university generally doesn't let the pharmaceutical company own. They will continue to just own the patent, but license it. And the pharmaceutical company will pay license fees off of that. Is that
Correct. I didn't quite hear the question. So if that's the question, then yeah, no, you're correct.
Yeah, he was just saying a pharmaceutical company works with a CHOP technology. How do they do that? And I think
Okay.
they don't own the patent. They would license the patent and then pay fees that are negotiated by an agreement.
Correct. So if a company wanted to develop an early stage technology at CHOP, what Cynthia described is the path that it would go. Now, I'm going to pause there because I think that was your question.
That was your question.
Yeah, thank you.
Anyone on the chat have any other?
We're a children's hospital, and we're also always looking for novel drugs or novel targets or novel therapeutics that could lead to a patent. Let's say there's already a full patent or an IP or trade secret somewhere else that's been shelved in some company and no one's developing it or no one's doing anything with it. Is there like a timeout if no one's doing anything with that, or can these companies just sit and protect an IP for years to come so no development can happen and it's at risk?
Yes, they can. And because they've been issued a patent, they have the right to exclude. Whether they execute on that right to exclude and exploit that patent is totally up to them. But you also will be able to find that patent by searching prior art. It's not like patents that are issued are secret. You can go and find them. So if you know that you're going in a certain direction and you do a prior art search and you find them and you say there is no product out here, it's just a patent, potentially that if you think that you definitely are going to infringe, potentially you might reach out to them and say, I'd like to license. A lot of times people will just invent and say, come and find me. And if you have a problem with what I'm doing, I'm not infringing, but you think I'm infringing, write me a letter. Because it costs a lot to force a patent. So that happens.
In the same space, I mean, are blanket patents used a lot in today's world? Like, remember, like the real old days, that blanket ESTs, for example, express sequence tags, we couldn't use them, but that was all. I don't know if that's still a thing anymore now or not.
I don't know if I understand the term when you say a blanket, because at this point there are 11 million patents that have been issued, and so patents, unless you're coming up with just a seminal technology, something that's completely changing how we think about things, it's probably an incremental patent. And so
it might have been my mistake. It might be sort of provisional patents over a large space. Might be. For some reason in my head, I saw it was termed blanket patents, but maybe that's the wrong terminology.
I haven't heard that, but it doesn't mean that it doesn't exist. It could exist in another, in certain fields, but provisional patents are definitely still used. We sometimes used to use something called a cover sheet patent that has gone a little bit out of favor, where basically it was nothing more than like some very basic information about the invention, and you put it in, and it was often done when you've got that Friday night before the Saturday disclosure and you just kind of have to throw something in. It's not great because they're not worth a lot, because you only get rights to what you have enabled, what you have disclosed. And so in a year, when you come back and you try to file that non-provisional, if what you filed a year ago is really like scrawl on the back of a cocktail napkin, you're not gonna be able to prove that you knew it then. And so generally what people are doing now is much more fulsome, robust provisional patents that even have claims and diagrams in them, so that when you go back a year later, you can use that provisional patent for a solid date, because you say, look, it's in the diagram.
Cassie nodding her head very vehemently to that comment about the
Correct.
work of the provisional patent, so that seems to align
So
with
it's
our
probably
practice
hard.
as well.
Yeah, it's probably harder for the universities because they have to pay more now upfront, because I think probably the more bare provisionals probably didn't cost as much, and now you need to spend more lawyer time to file provisionals. I wonder, does that change the analysis for you guys?
I think we always look at them in the same way. So we would never even, I mean, as long as I've been here, we weren't filing cover sheets because, as you mentioned, they're not very useful. So we would always look for the amount of kind of enablement, written description, and things that we would need, that we would be confident that we were, going to get some claims.
So can I go back to that question I asked before, Cassie? And I just want to make sure I'm not giving wrong information to people about talking at conferences.
Mhm.
I think the most important thing, and it doesn't matter if it's a patent or not, is to be careful not to disclose exactly who did something. You know, it's the same thing whether someone steals your idea and then recreates it in the lab and then they publish before you, or a patent. Like, I mean, people freely in like Silicon Valley, in Israel, other places, really talk about ideas, because an idea, like they just do. They want to make sure that there isn't something that can be copied in a minute, but they're a little more careful about talking about the secret sauce that makes that idea into something that's actually of value. So it's a little subtle, but it allows you to talk to people. But I want to know if that's bad advice.
No, I mean, if you're saying talk about your ideas on a high level, I think that's reasonable. But I think, as I mentioned before, if you're going to a conference and you have to submit abstracts and things to get there, you would be wanting to get in contact with the tech transfer office before you go to that conference, so that if you have everything that would be required for filing a provisional patent, it's best that we get that filed before you go to that conference, so that even if you do want to get a little bit into the weeds, you have your priority date. That just makes it easier for everyone, makes you more free and able to speak. Not saying you'd want to disclose every detail to everybody you talk to, but in the course of conversation, you just never know where it'll go sometimes. And with the safety of knowing that you have the provisional patent already filed before going to the conference, I think you can just not have to think about that as much.
And are provisional patents prior art?
No.
So they're not, they're kind of like your date, right? So if you have a provisional patent, everything before is prior art. But so let's say you went to that conference without talking to tech transfer, you made a public disclosure, there's an abstract out there. When you come back from the conference, you disclose to tech transfer, we do our prior art search, we can find that abstract, right? We could find that poster. Then you will essentially be prior art to yourself, right? So that is the scenario that we don't want, which is why before you go to a conference, before you write a paper and you're submitting it, disclose to tech transfer. I think sometimes where people get a little bit hesitant about, what is a real public disclosure might be something like you're going and you're collaborating with another institution, so like even between shop and Penn. So sometimes that is a gray area where it's like, you're not making a public disclosure in the sense that if I search the web, I'd be able to find it. But your risk there is that that person might get the information they need from you and be able to have their office file on something that includes your idea before you do. You know, in some cases, we actually even recommend putting CDAs in place, so confidentiality disclosure agreements, when engaging in those types of conversations, if there's, you know, a high risk. So yeah, I think sometimes we get questions about that, which I just wanted to kind of make a statement about that, just if anyone had, you know, that in the back of their mind. Because I know that we do interact a lot between shop and Penn.
A CDA, I've been using NDA, it's the same
Correct.
either. And provisional patents, just to be clear, are not even published. So they're not findable. So all they do is just sit at the patent office for 364 days. If you mature it into a non-provisional, then you get to use it. If you don't mature it into a non-provisional, it gets thrown away, and it never existed. So it's not prior art because it's not ever disclosed. It can only help you.
Does it still have the date though?
Sorry?
You'll still have the date though.
It has a good date.
Has a
It
date.
doesn't have a bad date. It has a good date for you. And nobody else can use your provisional
Right.
because it goes away. But if you choose to use it, it's your privilege. But it's not prior art.
Great clarification.
Thank you, Cynthia.